Hey guys, this is Professor Moore. This is an introduction to federal question jurisdiction. You should watch this video before our class on Wednesday, September 3rd, whatever Wednesday is. All right, so federal question jurisdiction is one of the two main types of subject matter jurisdiction of the federal district courts that we are studying this year in civil procedure. The other type, of course, being diversity jurisdiction, which we're just finishing up right now. So, as with diversity jurisdiction, there are two requirements that need to be met in order for a federal district court to take subject matter jurisdiction of a case. First, there has to be constitutional authority, and secondly, there has to be statutory authority. So, for example, to review the diversity jurisdiction, we recall that the Constitution confers the lower federal courts with subject matter jurisdiction over cases between citizens of different states. Then Congress also provides subject matter jurisdiction over diversity cases by 28 U.S.C. 1332. So the grant of subject matter jurisdiction to the federal courts, the lower federal courts, that is conferred by the Constitution of the United States is not self-executing. Congress must pass a statute that takes that grant of jurisdiction and by the Constitution and grants it through a statute. So in the case of so-called federal question jurisdiction, first let's look at all of Article 3, Section 2, and then we'll get to the part that really deals to federal question jurisdiction. So there you see all of Article 3, Section 2, and I've highlighted in red the portion that deals with federal question jurisdiction. Now let's look at that portion more carefully. So the very first sentence of Article 3, Section 2 of the U.S. Constitution reads, "The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority." The part that I have underlined, which is also highlighted in red, this Constitution, the laws of the United States, and treaties made, is very frequently, if not always, sort of abbreviated to the simple words federal law. So when we say arising under federal law, whether we are referring to the Constitution or whether we are referring to the statutory grant of jurisdiction, we mean arising under the Constitution of the United States, the laws of the United States, and treaties made by the United States. So the words federal law are simply an abbreviation of that. So what is federal law? You probably have some sense of it, but since we're just beginning and you don't really study a lot of federal law your first year, probably the vast majority of your exposure to federal law this year will come from civil procedure. So let me just go through some major types of federal law that are out there. Obviously, there's the Constitution of the United States. So, for example, the Fourth Amendment to the Constitution protects citizens against unreasonable searches and seizures by the state. And suppose that the police violate that provision, and you bring a lawsuit, a civil rights suit against the police under the Fourth Amendment. That would be a case arising under the Constitution, arising under federal law. The United States Code is where most of the statutes are codified of the United States. These are the statutes that are passed by the United States Congress. So these are the ones that, in years gone by, the House of Representatives and the Senate would actually pass bills and send them to the president, and the president would actually sign them, and they would go into law. Even though in this day and age that doesn't really happen very much anymore, and I am being sarcastic here, although it's somewhat true, that is the general process. And there are tons of statutes out there, and most of them are codified in those books that you see there, the United States Code, or if you're going to look in a legal database that's electronic, such as, for example, Westlaw, you would look in the library USC. So say there's a statute that gives you the right not to be discriminated against on the basis of gender by your employer, and you believe your employer has violated that right, you would bring a case against your employer under that particular federal statute, and that would be, again, a case arising under federal law. The Code of Federal Regulations is also deemed to be federal law. These are very detailed regulations that are normally promulgated by a federal agency under a delegation of authority from the United States Congress. So they get into some very specifics, such as what are all the requirements that have to be met for a person to be eligible for welfare benefits, let's say. There are very, very detailed regulations that are in effect, and so if a person believed that their benefits were denied by the federal agency in contravention of the regulations, then they would be able to bring a case under federal law, in this case, for a violation of the federal regulations. And finally, there are, of course, treaties that are entered into between the United States and foreign countries. This is just a picture of the security treaty between the United States and Japan. This is a much less common type of case that would be brought that would arise under federal law. But if a particular party who had standing to bring such an action were to assert that a party was violating an international treaty that the United States was a party to, the case would arise under that type of federal law. Okay, so those are just some types of federal law. So we were talking about the two requirements for a federal district court to have jurisdiction of a case that involves a federal question. And the first grant was, of course, by the United States Constitution in Article 3. The second level of authority that the federal district court needs is a statutory grant by the Congress of the United States. And in this case, the statute is 28 U.S.C. Section 1331, which reads in its entirety, "The district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States." So there's your statutory grant of so-called federal question jurisdiction. And you'll notice here that unlike the statute that gives us diversity jurisdiction, there is no minimum amount in controversy requirement for federal question jurisdiction. So here's a question for you. So again, Title VII is a federal statute that prohibits employers from discriminating against their employees on the basis of race, gender, and national origin. So let's say that plaintiff believes her employer has discriminated against her in violation of this statute. So the setup of the lawsuit in terms of the parties would be plaintiff versus defendant corporation. Let's hypothesize that plaintiff is a citizen of Florida and that the defendant corporation is incorporated in Delaware and that it has its principal place of business in Florida. Plaintiff's damages are $50,000. In what court may plaintiff bring this suit? Federal court, state court, or both? I'll give you a second to think about that, and now I will go to the next slide. The answer is that plaintiff may bring this suit in either federal court or in state court. So if the plaintiff wanted to bring it in federal court, she would do so under the jurisdictional grant of Section 1331. This case could also be brought in state court. Okay, so you may have noticed as we were going through the operative language in Article 3 and in Section 1331 that the operative language sounded very, very similar. In Article 3 it says the judicial power shall extend to all cases arising under this Constitution, the laws of the United States, and treaties made. And 1331 says the district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. So those words that are underlined there are pretty much the same. Do they mean the same thing? First, let's look at what is interpreted to be the reach of the constitutional grant of federal question jurisdiction to the lower federal courts. And that is still held to be delineated by an old case decided by the United States Supreme Court called Osborne versus Bank of the United States, and that is cited on page 90 of your casebook. And the test there was when a question to which the judicial power of the Union, in other words the United States, is extended by the Constitution, forms an ingredient of the original cause, it is in the power of Congress to give the lower federal courts jurisdiction of that cause. So when the Supreme Court used the words the original cause, what they meant was the basic suit, the complaint, the answer. So if there is some question of federal law, whether it be under the federal Constitution, a federal statute, a federal regulation, a federal treaty, when some question under federal law just forms an ingredient of the case, then constitutional authority extends to that case to give the lower federal courts jurisdiction of that case. So very, very broad grant of federal question jurisdiction by the Constitution. But as with diversity jurisdiction, the statutory grant of federal question jurisdiction in 1331 is interpreted to be much narrower than the constitutional grant of federal question jurisdiction. So in the Venn diagram that you see on the screen, the scope of federal question jurisdiction under 1331 is only a subset of the constitutional scope of federal question jurisdiction. So we will start looking at what exactly the Constitution, or excuse me, the statutory grant is under 1331 when we discuss the Motley case in class on Wednesday. and we will see how much narrower the statutory grant is. So thank you for watching, and I will see you Wednesday.